Good morning. Conducting criminal cases under the adversarial system of criminal jurisprudence is an art. Young lawyers should understand how to conduct criminal cases because cases filed on police report under 173 CRPC is being taken on file under 190C, complaint being taken for cognizance by relying the 173 final report. So thereafter issue of process and supply of copies 207, and the final report would contain FIR, 161 statement of witnesses, accident report, the postmortem report, and witnesses statement recorded under 161 CRPC, which will not contain the signature of the witnesses. Under 162 CRPC, these 161 statements will not be considered as evidence before the court. So 161 statement copies will be served to you, and other documents, Magajar, medical certificate, accident report, wound certificate, etc. You have to go through this entirely and keep the dates, events and particulars available about all these things. Then if suppose witnesses, there will be two category of witnesses, eyewitnesses and circumstantial witnesses. Whoever the witnesses may be, the 161 statement will be there. Therefore, it is your duty to follow the evidence, chief examination given by the witnesses. And if there was any contradictions with the 161 statement on table and hand with you, and his deposition is totally different before the court, that tantamounts to contradictions. Whether that contradiction is material contradictions or not, it is court to appreciate the evidence and you have to argue. The next question is, if suppose he improve the 161 statement, give some more information other than the information stated in the 161 statement, it is your duty to elicit through that witness whether he did say so before the investigating officer. That area will be called omissions. So contradictions, omissions played a vital role. Therefore, at the time of cross-examining the investigating officer, you have to get answers from the investigating officers. What was the actual statement made before him under 161 statement, contradicting to the evidence before the court. Contradicting to the evidence before the court and 161 statement before the investigating officer. And the witnesses failed to give such information which was now deposing before the court, that will be called omissions. So to make you understand what is contradiction and omission, this judgment will definitely help you lot. Judgment was written beautifully. This is AR 2025 Supreme Court 845. AR 2025 Supreme Court 845. Vinobai versus State of Kerala. There the court has held, after conviction by the trial court 302 IPC and confirmed by the High Court, Supreme Court has acquitted him, stating that material omissions and contradictions. Accused stabbed deceased to death with a knife due to perversity. One eyewitness stated that he was on motorcycle distributing newspaper and he saw accused attacking deceased. Witness claimed that the accused threatened him with a knife and forced him to take him near bridge 1.5 kilometers away. And other witnesses failed to inform about the presence of this accused before the court. Therefore, they did not try to inform the police immediately, nor produced the blood-stained shirt, and that apart, they have not made any attempt to move the deceased to the hospital. As a case, therefore, kindly go through this judgment. After discussing the entire evidence, the Supreme Court has stated that what all are the omissions. The statement made by both eyewitnesses that the appellant inflicted 2 or 3 stab wounds on the back of the deceased with a knife are omissions. So even before the court they would have stated that these injuries was caused on the back side. But that was not stated before investigating officer. They say that it is material omission. Version of PW4 that he was standing at the distance of 15 feet from the scene of occurrence is also an omission. So that is whether that is material omission or not, the court has to decide. Then statement of PW5 that PW4 was present at the time of incident is an omission. He did not stated anything about the presence of PW4 under 161 statement, but before the court he has stated that. Therefore, that is omission. Both the witness did not report the incident to the police, and the PW4 informed the incident to one Sumesh who has not been examined. Both the witnesses did not take the deceased to the hospital. Then, though the persons were present, the said witness have not been examined. So, failure on the part of prosecution to examine some important and vital witnesses and omissions and contradictions, the court get agreed. Go through the entire very few pages. Keep this judgment on file and record. Best wishes.